Welcome to Episode 5, an audit of the judicial stewardship in America, a measurement in the key of Ikita's subleg, or equal justice under law, measured not by the opinions it writes, but by the oath it swears, and the distance between what that oath promises and what justice delivers. Above the court's entrance are carved these words, equal justice under law. This ledger asks only one question. Does the record reflect the inscription? Every federal judge swears the same words. I will administer justice without respect to persons, and do equal right to the poor and to the rich, and faithfully and impartially discharge the duties of this office under the Constitution. For promises, no favoritism, no wealth preference, no partiality, no escape from the Constitution. This episode measures how often those promises were kept and how often they were not. Alexander Hamilton called the judiciary the least dangerous branch because it holds neither the sword nor the purse, only judgment. When judgment fails, there is nothing left to shield the powerless. The ledger measures what judgment costs when it looks away. When the court is wrong, how long do people suffer? Dred Scott versus Sanford. A man declared rightless, had no rights which the white man was bound to respect. Correction came 8 years later, after a nation buried 600,000 dead, and the Constitution had to be rewritten to say what should have been obvious. Plessy versus Ferguson. Separate but equal. 58 years of separate schools, separate water fountains, separate futures. Then one morning the court whispered, "We were wrong." Korematsu versus United States. 120,000 citizens locked behind barbed wire because of the blood in their veins. 74 years later, the court repudiated it in a footnote. Buck versus Bell. Forced sterilization upheld. Justice Holmes wrote, 3 generations of imbeciles are enough. 60,000 people sterilized. Most of them poor, most of them women, most of them without choice. The precedent has never been formally overruled. 97 years and counting. When justice arrives decades late, the ledger records the time as harm. Every year of delay is a year someone lived under an unconstitutional regime the court failed to correct. That time has a cost. The ledger counts it.
Voting rights weaken not by open denial, but by withdrawal of protection. Shelby County versus Holder. The court gutted the Voting Rights Act. Section 5 preclearance removed. The court said discrimination is over. Within hours, the past began voting again. Polling places closed. Voter purges accelerated. Maps drawn to predetermine outcomes. The right to vote protected by the Constitution in 5 separate amendments, and the court stepped aside. Rucho versus Common Cause. Partisan gerrymandering ruled non-justiciable. Courts can touch nothing. Districts drawn in advance to decide elections. Votes diluted by design. When the court steps aside, the powerless have no recourse. The ledger records what the court permits by refusing to act. Bodily autonomy. A constitutional protection withdrawn in a single opinion. June 2022. Dobbs versus Jackson. The court returned abortion regulation to the states. It did not say what the states would do with that power. The ledger recorded what they did. Within weeks, clinic doors locked. Waiting periods extended. Exceptions narrowed to invisible lines. A woman with a non-viable pregnancy, a fetus incompatible with life, could not end it without written approval. Physicians delayed. Lawyers were consulted. Pregnancies continued while tissue died inside the uterus. Sepsis followed. Hemorrhage followed. Some women bled in parking lots. This is not metaphor. These are documented cases. These are hospital records. These are death certificates. The ledger does not traffic in potential harm. It counts actual bodies. Maternal mortality increased in banned states. The data is preliminary, only 3 years post-decision, but it is clear. Women denied abortion access experienced higher rates of pregnancy complications, medical emergencies, and death. The economic burden fell on them. The physiological burden fell on them. The risk fell on them. Meanwhile, the wealthy traveled. The connected found exceptions. The powerful were never constrained. Equal right to the poor and to the rich. The oath was sworn. The ledger measured it. The court did not intend this outcome. The court did not measure it. The court does not appear to be measuring it now. The ledger does. Every month of delay in recognizing these harms is another month women bore the cost alone. This row will remain open until the measurement is complete, and the ledger will not forget that it took a pandemic, a war, a generation's worth of argument to secure bodily autonomy once before. The court gave it back in a single paragraph. The record is not one-sided. The ledger would be fraudulent if it claimed otherwise. When judgment aligned with the oath, it became the shield Hamilton imagined. Brown versus Board of Education, Gideon versus Wainwright, Loving versus Virginia, Miranda versus Arizona, Lawrence versus Texas, Obergefell versus Hodges. Liberty expanded because 9 people remembered their promise. The surplus is acknowledged. It is not an offset. It is proof of concept. It proves the court knows how to keep its word, which makes the breaches not failures of ability, but failures of will. 2 truths coexist in the record. The judiciary has protected the powerless when every other branch failed. And the judiciary has delayed correction long enough to let injustice harden into generations. The ledger does not average these truths. It refuses to offset them. One does not erase the other. The oath requires fidelity in every case. In this one, and the next one, and always. The bench is empty. The scales remain tilted. The gavel rests on its side. But repair is not hypothetical. The mechanisms are written into the system they oversee. The court can grant certiorari to the next qualified immunity appeal and reverse. It can interpret the Voting Rights Act's remaining sections to restore preclearance in fact, if not in name. It can recognize a right to counsel in civil cases where basic human needs, shelter, sustenance, family, are at stake. It can do these things next term. The question is not can it. The ledger's question is, why hasn't it? Justice delayed is measurable. Justice denied is recordable. The ledger exists because correction is possible, and because time costs. How long will it wait while the ledger counts? I will administer justice without respect to persons, and do equal right to the poor and to the rich. The oath was sworn. The ledger counted whether it was kept. This was a measurement of oath against outcome. The ledger is public. The record is ongoing. Equal justice under law. The ledger is listening. Always forward moving. Ever alive. The light above. The water below.